Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 19-793, Angel versus Tauch from Harris County and the 14th Court of Appeals District. Justice Lehrman is not participating in the decision in that case. Then is 19-831, Phillips versus McNeil from Travis County and the 14th Court of Appeals District. And finally, 19-1069, in the interest of J.W. Child from Brazos County and the 10th Court of Appeals District. Court has allotted 20 minutes per side in each case for argument. The arguments are being webcast this morning live and will be available in the archives later today. We're ready to hear argument in 19-793.
May it please the court, Ms. Block will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Good morning, Chief, Justices, and may it please the court. In Antwine versus Reed, this court adopted the rule that an outstanding offer is impliedly revoked when the offeree learns that the person making the offer has taken some action inconsistent with the offer. And there are two parts to the implied revocation test. Is the offeror's action inconsistent with the offer? And was that action communicated to the offeree? And this case focuses on the first part, the bank's inconsistent action. Was the bank's action inconsistent when it agreed on April 13th of 2016 to assign the judgment that it held against Tauch to Angel? I'll refer to Virginia Angel as trustee in her capacity as trustee, as we did in the briefs as Angel, her last name. So the bank's decision to assign the judgment that it held against Tauch to Angel, was it inconsistent with its outstanding offer to settle with Tauch for $1 million less? And specifically,
Counsel, does the inconsistency have to be unequivocal? We talked last term in BPX about in the waiver and ratification context that the action needs to be unequivocally inconsistent. Would you say that's also the test here?
that's the test under the restatement. I don't believe this court has ever specifically adopted the restatement, but the restatement principle is embodied in the court's decision in Antwine. Antwine doesn't use the word unequivocal. Restatement also uses the word definite. I'm fine with either definite or unequivocal because I think we certainly meet that here.
Why isn't there a fact issue if it has to be unequivocal on the facts here where you've got an assignment that can be unilaterally canceled at any time that's future dated? Why isn't there a fact issue on whether that's unequivocally inconsistent with the ability to accept the offer?
There are lots of questions there. First of all, the fact issue. The facts are undisputed. Both sides move for summary judgment, motion for summary judgment, counter motion.
But the intent is not undisputed, right? Because this is an implied revocation, and so aren't those often fact issues?
Well, two answers to that, Judge. First, intent is not subjective, it's objective. It's objective intent manifested by the action of the parties. And the action is undisputed. But I submit to you, if you look at, I believe it's page 18 of Tauch's brief, they admit in their brief that, and I'm quoting here, the assignment unambiguously evidenced an intent to transfer the assigned right in the future on the specified effective date. So Tauch even recognizes that the assignment embodied a present intent, unambiguous intent by the bank to assign the judgment to Angel the very next day. And your question also asked about the future date. Is that relevant? And I submit to you it's not. And that was the key to the Court of Appeals holding. The Court of Appeals determined that the agreement that was signed by both the bank and Angel on April 13th was not inconsistent with the bank's offer to settle with Tauch for $1 million less, simply because it wasn't effective until the next day. And let me just jump right to that, because I think that's a key issue here. The assignment itself was signed by both the bank and Angel on April 13th, and it was to be effective the next day. And again, I keep going back to that quote in Tauch's brief, that it was an unambiguous evidence of the bank's intent. And that's what's critical. Chief Justice Frost, in her dissent, was spot on when she said the effective date is irrelevant. It doesn't matter whether the assignment was enforceable by Angel on April 13th. What matters is the objective evidence of the bank's intent, and the assignment that was signed by the bank, that written document embodies the unambiguous intent of the bank to assign the judgment to Angel for $1 million more than it would have gotten under its outstanding offer to Tauch.
Is the assignment of the debt unequivocally inconsistent with the ability to accept the offer if the assignment can be canceled?
Well, a couple of things. It can be canceled only on 45 days' notice, but I point out that lots of contracts have termination provisions, have option periods, a free look. Even real estate contracts have option periods. Lots of contracts have termination provisions where either side, as here, can terminate on a certain number of days' notice. But the ability, the option that someone might exercise in the future doesn't negate the present intent that that party has the day it signs the contract to go ahead and do the deal. So the option doesn't negate the bank's present intent. And again, Tauch recognizes that it's an unambiguous evidence of the bank's intent. And you mentioned the inconsistency. So we've talked about the 45-day termination provision. Tauch points out other inconsistencies in the judgment, and I'd like to address those. He argues that, well, the assignment was for collection only. Well, that makes sense, because the bank was going to be paid its $3 million out of Angel's collection efforts against Tauch. And the bank knew, and context is important. The bank knew at the time it signed the assignment and did the deal with Angel, it knew that Angel had frozen more than $7 million of Tauch's funds from the TRO in her collection efforts on a different judgment. So the money was sitting there. So for collection doesn't make it ambiguous or unequivocal. And think about this, if the bank had released Tauch, which is what it would have had to do under the outstanding offer to Tauch, then there would be nothing left for Angel to collect. So the only inconsistency is between the assignment to Angel and its prior offer, the bank's prior offer to Tauch. That's the test. If it's inconsistent and Tauch knew about it, that terminates his power to accept the outstanding offer, and that's what happened here.
The restatement says that a binding contract with a third person doesn't necessarily revoke an outstanding offer, and that makes sense if you think about some of the mergers that are in the news these days. There's railroads bidding for other railroads that have been reported about, and they want to be free to accept a higher offer, right? So if we adopt a rule that a contract with one person revokes a prior offer, are we going to mess up that merger practice?
I'm not an M&A lawyer. I don't know all the intricacies of that. But I submit to you that it is a sound principle. Communication is the key. First of all, I agree with the restatement that merely entering into a contract with another party is not enough to revoke an outstanding offer, because it has to be communicated to the offeree. So if the offeree does not know that the offeror has entered into a contract with another party, the offeree's power to accept the offer has not yet terminated.
Does it make a difference here that the communication didn't come from the offeror? Would that have made it more unequivocal? Or unequivocal?
Unequivocal or equivocal doesn't come into play there. What comes into play is reliability. And so you do have the additional requirement that when information comes indirectly from a third party and not directly from the offeror, the information itself has to be reliable. And the reliability requirement and the objective standard of a reasonable person and the fact that we're dealing with objective intent of the offeror, those all provide the safeguards to ensure that if the offeree receives good information, reliable information about inconsistent action that the offeror has taken, then the offeree's power to accept the previous offer is immediately terminated.
Which seems like a really weird rule of contract law to me, because I know what we said in Antoine, but if I make an offer, shouldn't the burden be on me to let you know that I'm withdrawing that offer? Just as a matter of fairness in the contractual process, to make you pay the price of my inconsistent conduct when I've not made any effort to let you know that I'm withdrawing that offer. What if it's been 2 months and you've been spending lots of money preparing for getting yourself in a position where you can accept the offer, and only then do I find out indirectly from some other source that I've done something inconsistent that now impliedly revokes it. I mean, it just seems like bad contract law to me.
Well, a couple of thoughts there. It's not bad contract law. We need hard and fast rules when you're dealing with the fundamental principles of offer and acceptance. We don't want squishy, fact inquiries into, what was one party's subjective intent, which is really what your question comes into
Well,
play.
no, what I'm suggesting is that the hard and fast, easy rule without squishy facts is that an offeror cannot impliedly revoke. The offeror has to let the offeree know, I'm hereby revoking. I know that's not Hornbook law.
That's best practices. I'm sorry.
I know it's not Hornbook law. I know what we said in Antoine. I'm just having a hard time trying to understand why this would be the law.
Well, there's two reasons that there might be a firm offer. One is under the UCC, you might, if you had a sale of goods and services, you might exercise under the UCC a firm offer by saying, I'm definitively making this offer and it shall be open. The other is an option contract. Did we have either of these in this case?
No, we didn't. We didn't. And let me go back to you, Judge Boyd. We do need hard and fast rules. It's certainly best practices for the offeror to have communicated directly to the offeree that the offer is revoked. But we have the implied revocation doctrine for a reason, because it does happen. It does arise. It's not uncommon for an offeror to be dealing and negotiating with multiple parties. There may be an offer outstanding. Certainly best practices would be for the offeror to communicate the revocation directly. That's express revocation. But cases, Hornbooks, treatises, Williston on contracts, Corbin on contracts, they all recognize the implied revocation doctrine has an important place in our body of law dealing with contract formation. And we do need hard and fast rules so that parties know whether or not they have an agreement. Otherwise, we do get into these fact issues.
But Corbin also says if you have more than one offer out there on the same, whatever it is here, it happens to be a debt, that it's the person in the bank's position that takes the chance that more than one person is going to accept that offer.
Sure. That the offeror is in control of the offer. The offeror may put limitations, may make it unlimited, may say you've got to respond by a certain time. But we have to have a hard and fast rule about when the offer is revoked. It's certainly revoked by express language from the offeror that the offer is revoked. But again, implied revocation comes up because we don't always have that communication. And it makes sense because when the offeree learns that the offeror has taken action inconsistent with the offer, you talk about equities. Equity should prevent, at that point, the offeror from trying to, as Williston says, snap up what the offeree clearly knows is an offer that's no longer on the table. And so that's where the equities come into play there. And I want to go back to the reliability of the information. I don't think that should be an issue, but
So on that point, when you
Yes.
talk about reliability, are you looking and evaluating both the reliability of the speaker, the source of the information, as well as the substance? Because in this case, we have a competitor to the transaction who's the speaker, making it, in my view, somewhat unreliable.
well, here's why, and remember that the notice to Tauch was a two-step process. First, there was the email from Mr. Schwartz to Tauch's lawyer announcing the assignment, and that was followed up by the written assignment itself. And the written assignment was signed by the very same bank representative, Mr. Holden, with whom Tauch had been dealing in his negotiations with the bank. So when Mr. Tauch opened up that assignment or looked at it on his computer, he saw the manifestation of the bank with the bank's signature, the same fellow that he'd been dealing with at the bank. And I submit to you, that's pretty much as good as direct revocation communication coming from the offeror itself.
So it's a contract, the fact that they sent Tauch the signed contract sort of makes the case here, makes this, in your view, an easy case.
I think it is an easy case.
What if the contract had not come over and instead all you had was Angel's lawyer's representation that there had been an assignment agreed to? Would that be
That
sufficient?
absolutely would have been enough as well,
Matter of law.
matter of law.
Any other questions? Thank you, Ms. Block. We'll hear from the respondent.
May it please the court, Mr. Goals will present argument for the respondent.
May it please the court. We don't dispute that revocation requires inconsistent conduct. We simply maintain that revocation in any form, whether it's express or implied, whether it's direct or indirect, requires clear and unequivocal action, either clear and unequivocal words or conduct that demonstrates that the offeror no longer intends to enter into the proposed contract. And here, with the assignment, that standard simply is not met. Now, taking a step back and
Isn't the
looking
bank official signature enough?
the signature alone, no, because to determine inconsistency, we need to look first back to the terms of the offer itself. Mr. Holden, the senior VP of the bank, tells Mr. Tauch on April the 11th, please let us know as quickly as possible as we'll likely be looking to other collection alternatives. That's the last communication he receives from the bank. 2 days later, he receives this assignment. Once he actually receives the assignment, because bear in mind, the email regarding the assignment, every statement in that email about the assignment was incorrect. It was not presently effective and nothing had yet been assigned. And Angel had no rights under the judgment on the date that it sent that email. But looking at the assignment itself, reading it, it purports to be that other collection alternative that Mr. Holden had stated in his email. And you can look at the effective date, and it's handwritten. And it was handwritten by the bank's representative itself. So someone in Tauch's position can look at this assignment based solely on the effective date and see, well, look, Holden told me I better hurry up and accept, or otherwise we'll be looking at these other collection alternatives. This assignment purports to be effective on the 14th. That would convey to a reasonable person, well, hey, I have until the 14th to accept, and that's precisely what he did. Now, you could look even further at the assignment itself if you're going to go peel back beneath the layers and look at the terms itself and see even after the 14th, it appears that the bank still had rights under that judgment. Justice Busby, you mentioned the cancellation provision, that it could cancel it at any time. It also provides that the assignment was made without recourse. And it also provides in paragraph 5E, well, we included this in the bench exhibits if you'd want to take a look. Paragraph 5E of the assignment appears to indicate that the bank still retained the right to collect under the judgment itself, even after the effective date. So even looking beyond the effective date, if the bank still retains the right to collect the judgment, if their assignment was made without recourse, and the bank could cancel at any time, how is that supposed to unequivocally demonstrate that the bank no longer intended to enter into a compromise settlement with Mr. Tauch? I think it conveys exactly the opposite. But in any event, if
Is it that the bank has assigned its right to enforce the debt, thus precluding it from settling the debt for a sum that's less than the amount of the outstanding amount due? In other words, it's the bank's position that they've assigned away the right to enforce the debt. Someone else is going to be enforcing it. And so is that inconsistent with entering into an agreement to settle that debt by the bank instead of the person that it was assigned to?
No, I don't believe so, Judge. I think not necessarily it's the right to enforce, but it's just who do we pay? Do we pay the bank on the 14th, or do we pay the collection agency on the 14th? Either one, it says nothing about the intent to accept a lesser amount for the judgment. If you look at the payment provision.
It's the release part, right? In satisfaction, the settlement would obtain, Mr. Tauch would no longer owe anything outstanding. So did the bank have the right to release that debt?
I think so.
Once it assigned the enforcement of it to someone else?
I don't think the assignee ever retained, even after the effective date, I don't think the assignee itself ever had the right to release that debt, even after.
But you think the bank continued to have that right, even though it had given enforcement rights to the assignee?
Right, it gave permission to Angel to collect, but not even the exclusive right to collect. Because again, if you look at paragraph 5E, that purports to be a limitation on the bank's right to institute its own collection efforts. And the bank merely promised, hey, we won't institute collection efforts using your confidential information. So if they didn't retain the right to collect the judgment itself, there's no point in them putting a limitation on that right. And that is after the effective date. This would be, I think, a closer case if the acceptance came on April 14th. But, we're supposed to look at what the offeror communicated to Mr. Tauch. To the extent that you can look at the assignment itself as a communication to Mr. Tauch, all that it was communicating was that on April 14th, some right would be assigned to Angel. And it said nothing about the bank's intent or not to accept a settlement offer at any time before April the 14th. And remember, too, that the mere act of entering into a competing agreement isn't necessarily inconsistent with an intent to enter into that other contract. Justice Busby, you mentioned that in your statement. I'll also point the court to the Southern Oil opinion we've cited in our briefing. It's also cited in Antwine. And in that case, it actually appears to be an implied revocation case, although those words aren't used, where you had you had a settlement offer or agreement, and you had a prior agreement to sell stock in the company. And the mere existence of that other agreement didn't necessarily revoke the settlement offer that was at issue in that case. So the mere existence of this contract does not necessarily demonstrate an intent by the bank to revoke its settlement offer to Mr. Tauch. And if you look at the implied revocation cases as well, if you look at Antwine, the only other one I think is truly a revocation case is Kidwill. It's the memorandum opinion that was cited in the briefing as well. In each of those cases, you had a single offeror and you had multiple offerees. And as Corbin realized, that's not necessarily inconsistent. The fact that the offeror is pursuing multiple deals at the same time isn't necessarily inconsistent with an intent to enter into the prior offer, to enter into the prior contract. And if you look at the communications in this case, that's precisely what's happening. In the bench exhibits we've submitted, it's tab 3, various emails between the parties. What you'll see is that for a period of about 6 months, the bank is simultaneously pursuing 2 channels for recovery on that judgment. The first email in the record between Angel's representatives and the bank is mid-October of 2015. That's where Angel's representative reaches out to the bank and says, hey, we've got a couple other judgments we're working on collecting. We think we can collect on yours as well. Let's talk. The first communication from Tauch and the bank is end of November of 2015. And for the next 5 or 6 months, the bank is simultaneously negotiating both with Tauch on the settlement and with Angel in regard to a potential assignment. And even looking at the terms of the offer itself, if you look at the offer email, it's in Exhibit 1. If you notice the date and the time it was sent, Mr. Holden, the bank's representative, sent that offer to us at 4:04 p.m. on April the 11th, or I'm sorry, 3:57 p.m. on April the 11th. Just 7 minutes later, on that same day, is when Angel's counsel sends the initial draft of that assignment over to the bank's counsel. I mean, these are literally happening at the same time. And the narrative that Angel wants this court to accept is that at some point the bank made the determination it was only going to do a deal with Angel, necessarily to the exclusion of Mr. Tauch, and that simply is not the case. It's simultaneously pursuing two channels for recovery on the judgment itself. Now, you might ask yourself, why would the bank do that? Why would they want to leave the settlement offer open, notwithstanding this assignment to Angel? And the answer is pretty simple. It's uncertainty. There's an email in tab 3 of the bench exhibits, which sums it up precisely. It's on page, looks like it's 243 of the record. It's Summary Judgment Exhibit 8. And this is an email from the bank's counsel on April the 11th, which, bear in mind, is the date that the offer was made to us by Holden. And she expresses her significant concerns. Let's take a step back and remember, in these collection efforts by Angel, it wasn't only attempting to collect on the judgment we were fighting about. There were actually 4 judgments that it was pursuing collection efforts on. The assignment mentions 2 judgments. It mentions what's called the Angel judgment, which was a judgment held by Angel itself for roughly $600,000. The second judgment was the bank's judgment, which we're fighting about now as to whether there was a settlement. There's 2 other judgments that Angel is also pursuing collection efforts on at the same time. One is called the John Deere judgment. The summary judgment exhibits include a copy of the assignment pertaining to that John Deere judgment. It's about $1.1 million. The fourth judgment, I don't think there's any details in the record. Whitney Bank apparently was the judgment creditor of that judgment. So bear that in mind. There's actually 4 judgments that Angel is pursuing collection efforts on. And this is what this email is about. The bank's counsel on April the 11th states, I thought, and she's speaking to Angel's counsel, I thought your representative said last week you weren't sure how much money was out there to collect. And here's my concern, she says. What happens is if there's only $575K in Tauch's accounts? And they mentioned the TRO, that he had frozen his bank accounts. What if there's only $575K? What if that's only enough? That's only enough to make you whole. What about us? What are you going to do in that event? Are you going to continue to pursue collection efforts on our behalf? Or she says, are you going to kick the judgment back to us and say, have at it? She also says, what about the other 2 creditors you're working on behalf of? What happens to us in that event? And so there's substantial uncertainty. They want to portray as if it was a certainty that it's guaranteed that the bank was going to recover $3 million under this assignment. And this email demonstrates to you that contemporaneously at the time, that wasn't the case at all. Nobody was certain about anything. And this explains precisely why the bank would want to keep the channel for settlement open with Mr. Tauch. Remember, the offeror never said a word to Mr. Tauch about this assignment. There was no follow-up from the bank about, hey, we've revoked our offer, we've made a deal, nice talking to you. We'll let you know if we cancel it. None of that in the record.
Well, the acceptance happened at 6:12 p.m. The assignment was faxed over at 5:07.
Right. Well,
So
think about it, though. Holden is the one that dated that agreement. What would be his motivation on April the 13th to sign that agreement, but handwrite that it was effective on the 14th? And this is the only information that we've been presented. Again, it's not like Holden, as the court mentioned, it would have been one thing if Holden had emailed us on April the 13th and said, hey, we've assigned the judgment. That may constitute a revocation if it came from the bank itself. It would at least be less equivocal than the circumstances of this case, where we have no direct communication from the bank whatsoever. All we have is this agreement sent over to us that purports to be the other collection alternative referenced in Holden's email, and we have a handwritten effective date, meaning that nothing was to happen until the following day. In any event, they could cancel that at any time.
And I said accepted, but I think there's a question about the effectiveness of the acceptance. Do you want to address that as well?
Is this the net proceeds?
Whether the acceptance was effective. The acceptance of the offer was.
The only argument that would prevent the acceptance other than the implied revocation issue would be was it the net proceeds issue? Is that? Yes. Okay, sure.
Court of Appeals held there was a binding contract and that the acceptance was effective. And they argue it wasn't because it didn't substantially comply with the terms of the offer.
Oh, sure. Yeah, the argument, the gist of the argument is that because the term net proceeds weren't used in the acceptance, it's not really an acceptance. There's never been a requirement. The Amedesis case, we've cited in the brief, it's cited in the Court of Appeals opinion, there's never been a requirement that the acceptance has to literally match the terms of the offer, that the identical language has to be used. Just can't be a material variation. Here we don't even have a variation at all. If you look at Oral Argument Exhibit 1, we've highlighted some language in that exhibit, the offer and the acceptance. Look at the acceptance email. What word is right before $2 million payment? The. It's a definite article, necessarily referring back to what was stated in the offer in terms of the amount of compensation to be paid. Net proceeds of $2 million. Holden says we have authority to release your judgment for net proceeds of $2 million, and Tauch accepts it by saying we agree to the $2 million payment. Not a $2 million payment, the $2 million payment. And remember too, this was undisputed in the trial court. Nobody argued until the Court of Appeals that there wasn't an acceptance because of this net proceeds issue. And it's significant because we all read it the same way. Net proceeds of $2 million means $2 million. If you look at Oral Argument Exhibit 4, this is a letter from the bank's counsel, the bank itself, on April the 20th. And we've highlighted the language. She uses capital letters as if it's a proper noun. South State advised Mr. Tauch that it would accept $2 million for the judgment. I mean, again, that was undisputed. In their summary judgment response, they clearly state, the email states the amount of money to be paid. And again, earlier on in the summary judgment response, it states $2 million. So not until appeal did anybody dispute that there was an acceptance on this ground. But again, if you look back to the offer and the acceptance email, it clearly accepts the offer of net proceeds of $2 million. And it's a valid and binding settlement agreement because it was definitely accepted.
You know how much Angel paid for the right to collect the judgment? Is that in the record?
No. The best reading, I think the only evidence of that can be from the terms of the assignment itself.
It just says
I don't read it that any
consideration.
money changed hands whatsoever. The ploy that they appeared to be using was this, hey, we've got this TRO in place, we've frozen his funds. They act as if the TRO was perpetual and was going to forever freeze those funds. And that wasn't the case at all. If you look at the timing, the timeline they presented to you is interesting because in their first blank where the TRO was entered, I think it was like March 29th, they skip ahead about a month to the Rule 11 agreement, as if everybody knew at the time of the assignment that there were $7 million for one thing, and for the second, that those funds would always, the accounts would always be frozen. That wasn't the case at all. The TRO was put in place in connection with what's called the Angel judgment. In the assignment, it was that $600,000 judgment. It was a garnishment proceeding. That was extended by agreement on April the 12th, which was right around the time of the offer and the assignment. There was a subsequent amendment of that TRO to allow Mr. Tauch to pay that Angel judgment. The terms of that TRO specifically provided that upon payment of that judgment, that TRO would be dissolved within 24 hours, so that was going to be gone immediately. There was no guarantee that any further funds were going to be frozen. The Rule 11 agreement that they want to lump in with the TRO and make it seem as if that Rule 11 agreement on the $7 million in my firm's IOLTA account, they want to make it seem like that was in place in late March as well. That didn't come until about 2 or 3 weeks after the circumstances we're talking about now with the offer and acceptance and with the assignment. So this just goes back to the point that there was no guarantee at that time that the bank was going to collect anything. And you have the email from the bank's representative itself expressing that significant uncertainty as to what exactly was going to happen with the collection efforts, which explains precisely why it would want to keep the settlement offer to Mr. Tauch open to allow him to accept. I mean, look, think about the payment terms. It has a bird in the hand with Mr. Tauch, right? $2 million, not a payment plan, nothing like that, was going to receive a $2 million payment from him on the one hand. On the other, with the bank, look at that payment provision. I mean, The assignment doesn't say anything about the John Deere judgment or the Whitney Bank judgment, but it says that Angel is able to collect on her own judgment itself first, and that the bank is only going to be made whole, only going to be paid out of collection efforts on the South State judgment. So there's the potential that the bank could recover more through Angel, but there wasn't a guarantee that it would even recover less. There was no guarantee it would recover even a nickel, which is exactly why they would want to leave the cancellation provision in there. And further, why it would want to also allow the bank for the possibility to collect on the judgment itself, so long as that they didn't use confidential information obtained by from Angel, rather. They wanted to keep both channels of recovery open to make the best deal for itself, and that's exactly what happened.
The bank and Angel aligned in this case? I mean, does the implied revocation argument really resolve all things one way or the other, or could it be the case that Angel would be entitled to enforce her agreement with the bank, and Tauch would be entitled to enforce his agreement with the bank at the same time?
I think so.
They're aligned here, but I'm just wondering whether it has to be that way.
Practically, it may work itself out, such as if this court were to affirm. We can only speculate as to whether they've reached an agreement as to any potential conflicts or anything. But I think in terms of the settlement, whether the assignment, it would seem to me that if the settlement agreement is valid and enforceable, it merely, all the assignment would do is reflect who we pay it to, right? Would we pay it to the bank or would we pay it to Angel? Under the terms of this, it's an interesting assignment, right? It's not exactly clear. I think we can still pay the bank. But in any event, if we paid Angel, I think it's between them to work out who gets what. I don't know if it's a pro rata distribution as to, the bank gets a certain percent and Angel gets a certain percent based upon the payment provision. But either way, it wouldn't affect the validity and the enforceability of the settlement agreement. And that's an interesting point too. I think a layperson like Mr. Tauch could look at this agreement and say, okay, well, even on the 14th, just this merely affects who I pay. This isn't like Antwine. In Antwine, you had the definite, you had the bank's instruction to take the land off the market. This assignment didn't tell anyone that the judgment, as it were, was no longer on the market. It just said, okay, don't pay me, pay them. It was merely, it clearly states it was an assignment for the purposes of collection. And again, I think this would come into play maybe after the effective date, but because he accepted before the effective date, there's nothing in that agreement certainly that clearly and unequivocally demonstrated an intent by the bank to no longer compromise and release the judgment to Mr. Tauch. And on the implied revocation point, this case really comes down to two core issues. First of all, does a revocation have to be clear and unequivocal? And secondly, should the revocation have to be communicated by the offeror itself? And if the answer to either of those questions is yes, then the court should affirm. And we think under the facts of this case, because the answer to both questions should be yes, then the court should affirm the Court of Appeals judgment.
Any other questions? Thank you, Mr. Golds. Ms. Black, I believe you have 5 minutes.
May it please the court. A couple of answers to your questions, Justice Busby, on the consideration. I agree with Mr. Golds. You look at the assignment and it tells you what the consideration is. With Angel having frozen over $7 million of Tauch's funds, both parties knew that the money was there for the taking. And under the assignment, the bank would get $3 million first, and then Angel would get the remainder. So Angel, that was the consideration that Angel received. And then on the question about whether or not both could be enforced, absolutely not. They are inconsistent. The revoked offer to Tauch had been to release the judgment in exchange for $2 million. If a judgment is released, then there's nothing further to collect. And when Mr. Schwartz sent the email, and I was remiss in not introducing my co-counsel, Dick Schwartz, at counsel table with me, when he sent the email, he said, my client, Angel, has now been assigned the judgment, pay up, pay the full amount. And for the bank to get $3 million under the assignment, that's inconsistent with collecting only $2 million in its release of Tauch. So there's no way that both could be enforced at the same time. They are entirely inconsistent. And the issue here, the key issue is the objective.
But you have to pay before you would get the release. So what about Mr. Gold's point that the assignment affects who you pay to get that release?
Well, it doesn't affect how much are you going to pay? Only the $2 million? But then the bank doesn't get its $3 million under the deal. So the two are completely inconsistent with another. The issue is the objective intent, the objective evidence of the bank's intent. And again, Mr. Tauch admits that the evidence of the intent was unambiguously conveyed through the written assignment. It's a reasonable person standard. So what would a reasonable person in Mr. Tauch's position believe when he was holding that assignment in his hands or looking at it on his computer? Is it reasonable for a person to believe that the bank had gone in a different direction and decided to do a different deal that would get it more money? Or is it reasonable to believe that the bank had gone to the elaborate effort of negotiating a 4-page written, signed, sealed, and delivered contract with a third party for the sole purpose of inducing Mr. Tauch to hurry up and accept its offer that would have netted the bank $1 million less? And I submit to you, there's really only one reasonable answer to that question. The bank had decided to do a different deal on different terms with a different person, and Tauch knew it. And Judge, Justice Boyd, I want to go back to the question you asked about, what is the reason for this doctrine? And there are a number of good reasons for it, including we want clarity, we want hard and fast rules, but it also ensures another fundamental principle of contract formation. It ensures that the parties have a meeting of the minds. And when the offeree knows reliable information that indicates that the offeror has changed his, her, or its mind, and the offeree knows that, then there can no longer be a meeting of the minds. And that's why, under the implied revocation doctrine, the power to accept the outstanding offer is immediately terminated upon the offeree's learning that information. That is good, sound policy that this court needs to confirm. Our asks for the court are to reject the request that you change the law to require an effective contract. All that's required is inconsistent action. We ask you to reject the request that you change the law to require that the information be communicated only directly from the offeror. Again, we have the safeguards of reliability, objective standard, reasonable person test. All of those protect the integrity of the information, even when it comes from a third party. And we ask you to reject that the idea that this is only applicable in the context of real estate. We have the Walmart versus Shirey case we mentioned in our briefs that deals with a settlement, just like this one does, and other cases dealing with settlement as well. And I suggest this is really a classic first-year contracts law school exam question. And like a good exam question, there's room for debate, but ultimately there's only one correct answer. The correct answer here is that the information Tauch received was reliable, and immediately upon his receipt of that information, the written assignment unambiguously evidencing the bank's intent to do a different deal, his power to revoke the prior offer terminated.
Any other
Yes,
questions?
Judge.
Thank you, Ms. Block. The case is submitted, and the court will take a brief recess.
All rise.